we are gladdened by the fact that justice has been served. And there's no doubt in my mind that today's judgment was a landmark judgment, a judgment of monumental proportion that will enrich our jurisprudence. The judge or the justice of the Court of Appeal who read today's judgment abridged, and in his abridged version, spent an hour and a half. I mean, the full details we will be getting later. I'm sure that will go into about three and a half hours being read. He was able to bring everything to the fore. All the grounds espoused by us succeeded, and that there was no reason why they should have come here. A matter, a pre-election matter, which ordinarily should be 14 days, took 43 days, and even to judgment, 409 days, 209 days instead of 180 days. And the fact that, my Lord, the justice said that within the space, within the time that the court of the first instance, Honorable Justice Musa, was perverse, that he didn't consider, that he was considering other things. There was a key evidence, which he said strangely, when he was evaluating, he kept quiet on, and that's the affidavit from WAEC. WAEC came, swore to the head of exams, came, swore to an affidavit, and said, Senator Ademola Adeleke, candidate number 149, sat for the examination, and surprisingly, strangely, inexplicably, Justice Musa of the FCTI Court Buhari did not mention anything about that when he was evaluating, when he was giving his judgment. He kept quiet about that. And he was the one who said, why should come? So there were a number of things that surprised us there. But thank God, at the end of the day, justice was served.
You see, I came here personally as a national legal advisor of PDP because of the importance the party attaches to this case. Because if we have a candidate that is as educated as our candidate, and then somebody said he was not qualified, and the court affirmed that lies, we need to test it upstairs. That's why we came to the Court of Appeal. And today we have been justified. The decision the party took to field Senator Adeleke, who is a saving senator of the Federal Republic of Nigeria. Make no mistake about this. He has contested his election at that level before, and the qualification is the same. By section 318, it is the same. 1772 is the same. So, and he wants to contest for governorship, and they say he's not qualified. We need to come here to test that decision. So we are justified today because the Court of Appeal is standing with us. It has set aside the decision of the lower court and affirming our position that our candidate, who actually won the election in Osun State, was qualified for that election at the time we fielded him. So, and apart from that, apart from the qualification element, we have also said that bringing the case at the court at that time was statute barred in terms of being against section 285(9) and 10 of the Constitution as amended by the fourth alteration, that the matter was statute barred because it was not brought within 14 days. It was also statute barred because the judgment was delivered over 200 days as against 180 days allowed by the Constitution. Yeah. So the case was comprehensively bad. It was complicatedly bad. It was compoundingly bad. So it was a bad case for the plaintiff, and the bad case for the second and third respondent in this appeal.
Thank you, sir. Justices have decided, and then we, of course, naturally we are bound by the decisions. The only thing is just that there are some areas where we are of the view that probably we should have gone the other way. But like I said, the decision of the justices, they are the king here. For instance, on the issue of the testimonial, which we said that, which the principal said he never signed. For instance, another instance, the statement of results, which the school issued without a letterhead, but the one that was presented to INEC was with letterhead. So those were the things the claimants saw that they brought to court. And interestingly, the principal, when he came to court, agreed that he never signed the testimonial. He also agreed that the testimonial was full of errors. and he never issued it, even though his signature was there. And then the testimonial too that was issued without a letterhead, but the copy that was submitted to INEC was with letterhead. Those were the issues, the basic issues we submitted to court. So the other issues of whether he sat for WAEC and the affidavit brought by WAEC, the confirmation in the ledger and all those ones, they are extraneous. The basic issue that was submitted to the court was whether or not the documents, that is exhibits AA2 and AA3, which the appellant, Senator Adeleke, took to INEC, were the same documents issued by the school. That is the issue, the basic issue.
Are you going to appeal this judgment?
Well, it won't be my decision to say so now. It will be the decision of the client. For instance, the cost awarded against the client, the 3 million naira cost. Personally, my own opinion is that it's a bit onerous in the light of the fact that the court itself agreed that the observations were correct on the face of the document. But they said that, well, it doesn't matter. So if that be the case, I am of the view that the appeal will not be seen as frivolous, or the case will not be seen as frivolous. And if it is not frivolous, then the justification for 3 million naira cost is a bit harsh. Well, that is the decision of the court. We are bound by it. We will get back to our clients. They will decide on what to do the way forward. If they say they want to go on appeal, that's their decision.
Thank you, sir.
If they say they want to pay, that's their. My name is Bankole Joel Akomolafe.